and welcome back to another episode of Ex Ante. My name is Alex Dolphin, and today we're going to discuss the case of Foster versus Svenson. This was heard in the New York Supreme Court, which is truly a court of appeals, in the year of 2015. So it's a very recent case. It deals with privacy and invasion of privacy, along with a potential claim for intentional infliction of emotional distress. So we'll discuss all that. Let's go ahead and jump into the facts. So Svenson was a photographer in New York. He lived in an apartment building, and he decided that for his next piece of artwork, he wanted to shoot his neighbors across the way. So envision Svenson's living in one apartment. Across the street are his neighbors, which turned out to be the Fosters, the plaintiffs in this case. He began taking photos with a great telephotic lens all the way across the street and into their private residence. He would take photos of these people. Said his purpose was to display the facelessness of urban life, that there's so many people living in these cities and no one really, has any type of identity because the city's so large and they're so small. So that was kind of his goal in his artwork, was to portray that. He displayed the photographs in galleries in New York and Los Angeles. Ultimately, the Fosters, who were the unknowing subjects of his photographs, found out that they were the subjects of his photographs. So they found out that Svenson had been taking pictures of them, during their everyday activities. He had also been taking pictures of their young daughters. They were concerned. They immediately sought counsel and sought an injunction to get him to stop publishing the photographs. They claimed the tort of invasion of privacy, and they also claimed the tort of intentional infliction of emotional distress. So now we kind of have the facts. Let's go ahead and jump into how the court dealt with this. So the court had acknowledged that the New York legislature had passed a statute in the past, which prohibited the use of a person's name, portrait, or picture / voice for advertising or trade purposes. So it was in response to a prior case, and the statute that the New York legislature passed didn't allow any type of company to use your face and profit off of it expressly without your permission. You had a right to privacy, that your likeness wouldn't be used for that. There's a lot of litigation that came out of that statute, and ultimately the court created an exemption. And the exemption is for items that are newsworthy or of public concern. So items that are newsworthy or of public concern. So the New York Times could publish a picture of Donald Trump, for example, without having fear that they were going to be sued for an invasion of privacy because he is newsworthy or of public concern. Public concern was defined more broadly to include art. So forms of art are also considered a form of public concern and granted an exemption underneath the right to privacy in the statute. So the court ruled in favor because of this exemption of Svenson. They stated that because his photographs were ultimately art, they fell underneath the exemption, and the Foster family had no right to sue for an invasion of privacy. They write in the decision at the beginning and at the end that basically it's unfortunate. They didn't want to rule this way. They didn't want to rule in favor of Svenson because they felt that his behavior was a bit abhorrent, especially him taking pictures of, their young daughters without their consent or without, any type of agreement or notice. So they said that though they would have liked basically to have ruled in favor of the Foster family and said that this was an invasion of privacy, that prior courts had interpreted the exemption to include art. And since Svenson's photographs were art, they were granted an exemption and he couldn't be held liable for that suit. The court briefly deals with the claim under the intentional infliction of emotional distress, but it dismisses it rather quickly, saying that what Svenson does wasn't enough to inflict emotional distress, to intensively inflict emotional distress. So that's the ruling. I think intuitively it feels wrong. We don't want to say that a guy can just take pictures of people's children and then display those in galleries without any consent of those children. And the court felt that guttural feeling as well, but they had to rule the way they did because they were confined by the statute. And they noted that very explicitly, and they said that it's basically the role of the legislature to say that, what Svenson did ultimately was wrong, and they should write that into the statute. So, kind of the brief rule that could be gleaned from this is in New York, there's a newsworthy and public concern exemption underneath the statute that can be used as a defense for the invasion of privacy, and photographers can use this defense, to claim that their artwork isn't an invasion of privacy because it's artwork. So let's go ahead and jump into some of the implications, ex ante, and some incentives generated by the case. So first thing I just want to note is that it's kind of disgusting that you can do whatever you want in the name of art and it be granted an exemption. I didn't jump into this in the facts, but Svenson did take a picture of their daughter's topless, and that was in the facts of the case. He took a picture of his half-naked young daughter, the foster's half-naked young daughter, and that's just kind of disgusting. And if it were under the guise of anything other than art, it would have been held an invasion of personal privacy. But because we can call it art, now they're granted this exception. It just, in the gut, it feels wrong. It feels wrong, and I think it's especially wrong because he was making money off this. He was totally making money off publishing these photos because it was building his brand as a photographer. He was becoming a more notable photographer because of his exploitation of the Foster family and using exploiting their privacy for his own personal gain. So I really do think the court got this one wrong. They held that they were just confined by the statute. I think that they would have been better off creating a rule underneath the statute and allowing them to recover and allowing future people to recover against gross invasions of privacy like Svenson's on the Foster family. The court noted that in the case, the Foster attorney didn't really argue the definition of art. And that's a good point. We could argue, was what Svenson doing really art, or was it just business? And at what level does art become business? Are they synonymous with one another? Is business protected when it's art, or is art only protected if it's art in and of itself? So that's something to think about. The definition of art. Can we define this art in itself? So that's basically what I wanted to talk about. It might set the bar too low for the intentional infliction of emotional distress tort as well. It does seem like they inflicted some emotional distress, especially on the family. Taking pictures of someone's half-naked daughter will definitely inflict emotional distress. Is that bar set too high in this case that we're not going to allow future plaintiffs to recover for some gross activity that was done by Mr. Svenson? So something to think about there also. Finally, I just want to jump into one hypothetical scenario where this precedent set in this case might lead to something that's not intuitive. So let's run through, let's say there's an artist, right? He's an artist. And what this artist does is he takes all the pictures off your Facebook page and publishes them in a book that then he prints in a magazine or he sends around to people. But it's all it is the pictures off your Facebook page. As long as he claims this is art, I don't know why this wouldn't be an invasion of privacy underneath the ruling here in Svenson. So that's something to think about. Someone could just take all of your Facebook photos or your Twitter photos, put them on a separate page, call that compilation of your photos a collage or art in some sense, and basically redistribute that, use your likeness, make money off of it, as long as they claim that it's art. So the biggest implication of this is it's allowing people in the future to invade privacy under the guise of art. And I think that's the most negative impact of this. There are some positive impacts. We don't want to restrict free speech too much. Ruling in favor of the Foster family would, in a sense, restrict free speech, and it would go against that, fundamental right assumed in the Constitution. But the court has limited the First Amendment before and the freedom to speech, and I think that especially when it invades privacy and privacy of little girls, probably is a good time to limit that. So those are just some of the ex ante implications, along with just my thoughts and jargon over the case. Thanks so much for watching, and I hope you have a nice rest of your day.